When I was hungry, you fed me. When I was thirsty, you gave me something to drink. When I was a stranger, you invited me in. When I needed clothes, you gave me something to wear. When I was alone, you took me in. Whatever you did for the least of these, you did for me.
Welcome to Change the Story, a podcast by Fostering Change Washington, where we bring real stories from those who know the child welfare system best, from children who've lived it to frontline workers, experts, and leaders fighting for change. Every day, innocent children are left suffering and abuse, their voices unheard, their lives at risk. This is more than a conversation. It's a call to action to stand for life and justice for those who cannot speak for themselves. Thank you for joining us. Now, let's change the story.
Hey guys, it's Jamie on the podcast today. I just got done interviewing Jeanette Oblecz from the Social Worker Union in Washington. She is the union rep, and you're going to want to listen to this episode. She completely takes us like behind the scenes of how they passed 1227, the concerns that were ignored along the way. And it was pretty shocking. We never really knew kind of what went on behind the scenes of this bill, but she's taking us there. And in fact, I think this is going to be a 2-part series. So excited for you guys to tune in, and let's get started. We are recording. Hello, Jeanette. How are you?
Hi, I'm good.
Good, good. Thank you so much for coming on today. This is so unique, and I told our listeners on our Instagram yesterday that this was coming because I really wanted them to get excited, because after speaking with you to prep for the podcast, I only planned on talking to you that day for 45 minutes, and I think we stayed on the phone for like almost an hour and a half, and I hadn't even gotten through the rest of my questions yet. So just the knowledge that you're able to share with us is so enlightening, and I think it's really inspiring too that we're not alone in this and feeling very frustrated with this legislation and the legislators behind it that continue to just kind of turn a blind eye. And so, thank you for being here. And we're gonna dive right in. So the first thing I want to talk about is, for our listeners, we talk about 1227, which is the Keeping Families Together Act, quite frequently, but just in case anyone's joining us for the first time, can you just kind of briefly explain what the Keeping Families Together Act, otherwise known as 1227, changed about how and when children can be removed from unsafe situations?
Yeah, so 1227 completely changed the standard for removal for children in Washington state. Prior to 1227, it was substantial harm, and it changed that to imminent risk of physical harm. And that, because of Washington state's existing laws or non-existent laws, that actually created a higher standard of removal than even the Indian Child Welfare Act has. So you'll hear a lot of people talk about the Indian Child Welfare Act being the gold standard, and that this creates the gold standard for all kids. But really, it creates a higher standard. So there are children who tribes take jurisdiction of those cases, and those children are able to be removed safely. Whereas if they stayed in a Washington state court, they wouldn't be able to.
Right. Okay.
And it and it Washington state also doesn't have this point that does not have an emotional harm statute. So that's what makes it so much higher, because ICWA, the Indian Child Welfare Act, recognizes that your brain and your body are connected. It's not like it's not separate. So impacting development, impacting your mental health, that is a real physical harm that's being done that's going to have lasting impacts throughout your life. Washington state doesn't recognize that.
Which is so funny. And it's interesting because I mean, adverse childhood experiences and all that we have learned through that and what trauma does to the brain. In fact, we just released a podcast that goes deep into that and how it affects children. And so it's interesting to me that Washington State is the only state that's not recognizing that.
Yeah, it's really frustrating, because, you would think that, like, a parent who threatens to kill their child or who threatens serious physical harm to their child, that would be something that could be used in a petition to remove that child from the home. But at this point, the way our laws stand, it's not. 1227 also, made it so that parents have to be offered services at prior to removal in order to prevent removal, or if the police or hospital place a child into protective custody, that before we go to a shelter care hearing, that we have to offer services that would prevent the need for out of home placement. And if a parent agrees to those services, we basically have to give them a chance to participate. And that means that a a child who's technically by this law's standards, a child who is sexually abused by their parent, we would have to offer that parent services that to try and eliminate the need for removal. It means that if a child is seriously physically abused, that we would have to try to offer services. Um,
What would those services look like?
I have no idea. I I can tell you that I have not found a service yet that would prevent or eliminate the need for removal, but we do have cases where, a voluntary placement agreement is done before a case goes to shelter care. And what that means is that we're looking at an even longer term for permanency for a child, because now you get 90 days of a voluntary placement agreement. You get shelter care, which often gets continued much longer than it should. And then that time frame for permanency for the feds doesn't start until dependency is established. So you're looking at cases where a child can be in care for years before they have permanency.
Right. Yeah. That is one of the most frustrating things. I know myself as a foster parent has experienced that, where these children just linger. They just linger in the system and you're not making progress. And it can be just so infuriating. Were you or any other expert in the field asked to give any input or feedback by the committee and the sponsors behind this, the Keeping Families Together Act, House Bill 1227?
No, and if you look into the coalition, that the Keeping Families Together coalition that really put this together, what you'll find is that they've openly admitted to keeping experts out of the room. That they wanted it to be, you know, people who have been impacted, parents, caregivers, defense attorneys, and not experts in child safety, because they wanted it to really focus on the harm of removal and the harm that the system does. Um, so really those child advocacy voices were really left out of the discussion. The people who are experts in child safety were left out of the discussion.
Wow. Wow. I mean, it's shocking, but in some ways it's not, in the state that we live in. But you would think that if you're going to completely dismantle and disrupt the child fail process, that it would be vital to involve experts that are actively working in the field. Being a defense attorney does not make you an expert in this field. Would you say that's correct?
Yeah, I mean, I think that our defense attorneys are sorely needed. Every parent should have proper representation and good representation so that they have things like visitation and a fair shake, right? Everyone deserves a fair shake. Um, but they're not the experts on child safety. They're not the ones who are going to really intimately understand what the workload looks like and what it would need to make sure that this bill could be implemented successfully. It takes everyone sitting at the table.
Right. And they just left you guys out. They just kind of completely cut you out of it on purpose, it sounds like.
Yeah, I mean, that's my understanding.
Yeah. That's kind of what I've been told as well. I mean, you're not the only social worker that has um that has stated that. So, so when you look through the lens of a social worker, did 1227 raise any immediate concerns for you, and were you given an opportunity to voice those concerns at all?
So through my union, WFC, I did testify against the bill. We had our WFC lobbyists who also testified against the bill and worked behind the scenes to really explain what the workload impacts would look like. Because in looking at 1227 from kind of a case carrying perspective, my first concern was workload. We know that we don't have enough caseworkers already. We know that even if we were fully staffed, we would not have enough caseworkers. And then when you look at this bill, it really and raising that bar and changing so much, we immediately we would need more family voluntary services workers. We would need more child protective services workers because cases are staying in continued shelter care. That initial continued shelter care hearing is meant to be an emergency hearing, and we're seeing it be extended quite a bit. And we knew reading the legislation that that was something that might happen. We knew that it would take a lot more upfront work, and you only have 72 hours to make a decision a lot of times. We knew that it meant that there would be more voluntary placement agreements and more in-home services being provided. Um, and that then on after a case goes to court, that there would be a lot more going into making sure that if we believe that a child needs to be out of home, that they stay out of home. Because the evidence is so much more that's needed to be produced for that. Um, and the fiscal impact statement that the legislature does also said that we would need more workers. But also from a child safety perspective, raising the bar and knowing it in the context of other existing and non-existing Washington state laws also raised a significant concern that we would be having kids who would be staying in homes who we would consider unsafe.
Absolutely. So when you testified, what was their response?
There wasn't really a response. I don't think that people wanted to hear that there was issues with this legislation.
Wow. So their eyes were just kind of fixed on it, and they were moving forward.
Yeah, and I mean, as our previous secretary, Ross Hunter, said, how can you be against keeping families together?
Because it sounds like butterflies and rainbows, doesn't it?
It really does.
Right. Did you ever go to the oversight board? Because I've attended those meetings before. They usually have them monthly. Did you contact anybody there? Were they able to help you in any way get get those concerns kind of handed over to the people in charge?
Yeah, so I mean, the oversight board, as much, I think that everyone on the oversight board really cares about kids. They want kids to be safe. The oversight board, though, unfortunately, it's not really designed to make changes. It makes recommendations, but nothing that they say is, you know, it nothing they say has to be implemented. Um, and there was discussion at the oversight board. We provided public comment. We've provided public comment a number of times regarding 1227, workload, worker retention, a lot of different kind of issues. And there was a lot of discussion around, are we doing this safely? But there wasn't a lot of answers provided from the department about whether or not this is being done safely. Um, and I think that you know, it's hard it's hard to provide good data. A lot of things aren't tracked really well in Washington.
Yeah. I've experienced that same situation going to the oversight board, and you sign up for public comment, and there's no dialogue back and forth, so it's always like, thank you for your comment, moving on to the next comment. You don't you hope that you're making a difference by being there. But I mean, we've gotten our hands slapped before because they don't like the facts and the data that we're bringing in our public comment, and it's 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 frustrating because an oversight board must listen to the people working in the system it oversees. That's the whole reason of having an oversight board. And yeah, we've just recently had, minutes slashed off of our time because they're just kind of sick of hearing about it. And I get it, the truth is hard to hear, but and that's why we kind of have to amplify this. That's why we need the support of the oversight board, especially when it comes to amending 1227 in this next legislative session. So they do have another meeting tomorrow, and I've already signed up for
Me
my
too.
public comment. Oh, good. Okay. So yeah, I've already kind of prepared my statement, but it's just disheartening when, you kind of get your hand slapped and they just stop listening to you because they don't like what you're saying. And I mean, we get it. It's not easy information to have. It's not easy conversations to have, but these are all facts. These are all data that we're pulling from the ombuds. This isn't, you know, we're not, using derogatory language or being disrespectful, but yes, we're angry because we don't feel like our voices are heard. And just shocking that social workers as well, are just kind of in some way getting blown off. So given the massive increase in critical incidents, there is a lot of confusion on both sides of the aisle of around how this bill was approved with bipartisan support. Do you know how they presented this bill to legislators?
Yeah, so it seems like for Democrats, they presented this as something that would decrease disproportionality and kind of make sure that what what is termed as just neglect, that kids aren't removed for poverty. And there's a really big equating of poverty and neglect. Um, and that when we remove a child for neglect, that means that we're removing a child because their parents are poor. Um, and then on the Republican side, it was a parents' rights bill. It was a bill to uphold parents' rights so that the state stays out of it.
Wow. That that's interesting, and I'm even going to say that that's manipulative. I mean, when you completely change the messaging and you use kind of these targeted buzzwords to appease a certain political party in order to approve a bill, I mean, that is by definition manipulation. And it makes sense that they told Republicans that this was a parent rights bill because especially when they passed, Senate Bill 5181 that removed parents' rights to access their child's medical and mental health care and records. So it makes sense that Republicans heard that and went, "Oh my gosh, they're giving us parental rights back." Sounds great. Yeah, just fascinating, how it works over there in Olympia. So it and also kind of on that same point, the coalition that led the fight for 1227, they said, and this is a quote that I'm going to read, the child welfare system imports the structural racism of the criminal legal system. So essentially, the major argument was that CPS was disproportionately harming children of color by means of removal. um, I actually took a deep dive into this. I collected a bunch of the ombuds data and I looked at the trends of these minority groups that have been harmed the most. And this is what I found. I'm going to share this graphic with you. And I'd love to know what you think on who's being harmed the most after 1227. Can you see that?
Yes.
Okay, so 1227 passes in 2021. This is critical incidents involving children of color and up until the current data that we have, which is from 2024. And as you can see, it increases. It increases. So the goal and the driving force, it seems, was to remove that harm to families of color. But in reality, what that caused was harm. It caused harm to these minority groups. And in fact, even when you look at just taking it from a percentage, in 2019, 17% of critical incidents were involving children of color. You fast forward now to 2024, and it's 26%. And we know, based on what the Ombuds has released for 2025, that that number is only going to get worse. And so I think what's frustrating is, um, if you leave children in lethal environments, it doesn't matter what your skin color is or what your ethnicity or your race, drugs are going to affect all children. Levels of abuse and neglect are going to affect all children, not just children of color. And I think this just really debunks that. And I'd love to know what you think about that.
I think it was a huge failure of the legislature to implement something like this without actually backing it up with resources, number one. I think that fails all kids, to pass something and know that you are, from the day that you're passing it with that fiscal note, you know that you are not funding it properly to be implemented properly. So you know already that there are going to be serious unintended consequences. And I can't say with that 27% if there would have been a few that we could have kept together safely, if there would have been more resources, if there would have been the ability to have more oversight of cases, if we could have gotten to a point where we gathered enough information to prove to the court that a child should be removed because we had more time to spend with a family. There's a lot of factors that go into that, with the not funding this bill properly. And I also think that it's a failure to parents that half of these are because of fentanyl. We know that half of them are because of high potency synthetic opioids. And as a state, we are not intervening in those cases. When you are under the influence, you can't make good decisions. You can't decide, oh, I can't safely parent my kids, or I'm going to lock up my fentanyl. So we're really, like, the damage that is done when a child dies or nearly dies is so serious, and you can't reverse that. You can't reverse dead. But there's a lot that we could do as a state if we actually decided to invest in kids. All kids. If we decided to invest in kids, that could make it so that when they are removed, there is less harm done, that they have more supports, that they have what they need to thrive. And there is a lot that we could do up front to make sure that if a child isn't removed and we have concerns, that those concerns are addressed safely.
Absolutely. It just seems like common sense that you would lead with safety for the child first and then follow up with services for the parent. Nobody is wanting to strip away services and opportunities for a parent to better their life and get on a healthy track and be one family unit. But when you completely disregard the safety of the child, this is what you can expect to happen, especially during a fentanyl crisis. I want to play you one clip. This came from a kind of a fishbowl conversation with a lot of the people that were a part of this coalition. So let's go ahead and play that clip.
Destroying families, right? Like, sit with that on your heart and on your soul. And we destroy families under the best interests of children.
And my gut reaction to that is you sit with that. You place that on your heart and your soul that these children are dying and they don't have to. and it's preventable. And what would you respond
I think it
with?
destroys a family when a child dies, whether it's accidental or not. I mean, if you talk to any parent who has lost a kid, that destroys a piece of your soul like that. And I think when you have this increase in critical incidents, there's a lot of people hurt by that. There's grandparents involved, there's, extended family, there's siblings, there's parents, there's the caseworker who, no matter what you say, they blame themselves. Like, there's so many people impacted when a child unnecessarily dies. Um, when there's things that could have been done to prevent that death. Um, and I think that it really shows the approach, like how this bill was approached. This bill was approached with a very negative assumption about the child welfare system. And I would never deny that the child welfare system has been used to oppress people, to intentionally destroy cultures. Like, we have an Indian Child Welfare Act for very, very good reasons. Um, and it's unfortunate that something like that was ever necessary. But we are at that point when the bill was proposed, we were in 2021. Did anyone look at the last 5 years of data that showed that we were, as a system, decreasing the number of children who were being removed? Year after year, the number of children in care in Washington state was going down. And it was going down without our critical incidents going up. Fentanyl was already on the scene. The first time that Purdue Pharma was sued was in 2017. And we had 3 years where the child welfare system was facing a fentanyl epidemic, decreasing the number of kids in care, and we were doing it without increasing critical incidents. And nobody looked at that. Nobody said, hey, what's actually working? Let's talk to the workers who are making these really great changes. Let's recognize that good work is being done in our state. And it was done because, we had the FAR. We had family assessment response rollout, so that, we were separating kind of these low to moderate risk intakes from these higher risk intakes, so that we had workers who were dedicated to both of these situations. We want to prevent, these low to moderate risk families from getting into a crisis mode. And when a family's in crisis, we want a worker who's just dedicated to crisis mode. um, that was a really big change. And it also meant that the legislature actually had to invest in the low to moderate risk families. Now we have a system that is so overwhelmed and so behind that no family is getting the attention that they deserve from our child protective services workers. We have workers who are getting double, triple the amount of intakes that they should get in a month.
Wow. And to your point, I mean, when you look at that chart that we just displayed, critical incidents involving children of color were going down before 21. And then it shoots up. And this kind of leads into the next question I have for you. We did see a critical incident started to surge in 2021, which is the year they passed 1227. But arguments by legislators will be made that the increase in critical incidents is not related to the bill, because the bill was not enacted into law until 23. Were you aware of demands or change in expectations of social workers in regard to removal of children in 2021 after it passed? Did the environment within the foster care system, did it shift?
Yeah, so you can see in 2021 that removals went down significantly starting in 2021. And it started in 2021 because we had in Western Washington first, especially like in King County, Pierce County, Snohomish County, we had 1221 being used in courts before it was ever law. And we brought this to the attention of the department. We brought it to the attention of our lawmakers that this bill is being implemented early. And we were told you can't tell judges what to do.
Wow. Wow. Because that is a huge argument that is thrown back at us constantly. And we knew, I'm not even in King County. I am like the farthest away from King County that you can get in this state. I am like right on the border of Oregon. And I felt the shift as a foster parent in my very small town of Walla Walla. I felt it in 2021. Um, and definitely before 23, there was a huge shift. In fact, I just shared, my story on the podcast a couple of weeks ago where I was forced to send a baby back home to unsafe conditions. And that house ended up catching fire, and mom relapsed 9 months later, and the child that I had was forced to send home was neglected that entire time. No medical with high medical needs, and just completely poof, just gone. And so I will vouch for that. Like that is absolutely true. And I completely reject when legislators want to argue that, because it absolutely, policies started to change. Things started to change in 2021, and it trickled down to the judicial system. And that is just a fact. And even though it's a hard pill to swallow, it's a fact. And so it absolutely makes sense that we are seeing this huge climb that's not slowing down, that's continuing to increase after the passing of this bill. They passed another bill kind of in conjunction, right, with 1227. It was House Bill 1194, like the Family Time Act. Can you briefly explain what the Family Time Act is and the consequences that it has had?
Yeah, so the Family Time Act was specifically around making sure that, you know, a visit happened first within 72 hours, and then also that visits are occurring in really the least restrictive environment possible. And it's supposed to be based on, an assessment of safety. So, how long can you expect kind of a family, parents to maintain where they wouldn't have to be supervised or they could be monitored? And it did have good things with it. Before 1194, we didn't have kind of an emergency visit referral system where we could refer for a 72-hour visit to make sure that it actually happened. And there is a lot of research that goes into if a kid sees their parents shortly after being removed, like it does help increase stability, and it does, help that child emotionally. However, it did not take into account the system that Washington State has, where we don't have, despite these hearings being considered emergencies for shelter care, we have specific court days. Like my court days are Monday, and then I have an overflow day Thursday. So we can't go into court and get like a no contact order between a parent and a child on a 72-hour basis. And it's 72 hours total, so like it's not like business hours or business days or whatever. It includes weekends, holidays. But the bill, the way it reads, it says that you have to do a visit unless there's a no contact order or some sort of no contact order. So that means, again, like worst case scenario, under this legislation, we technically have to provide a visit to a parent if that child just disclosed that parent sexually abused them, unless we can get a no contact order, which we don't have the power to get. And it just goes to show that like the people who do the work were really left out of a lot of these conversations, because I don't think that anyone who wrote this bill had the intention that that would be happening. But technically, when I don't do that, I am breaking the law. I'm in contempt.
Wow. That is so heartbreaking. I mean, talk about reintroducing a child to trauma. Wow. That's horrific. That is awful. I'm gonna share this other this next little um image with you. I think this is just interesting. So this screenshot came from a training for foster parents, like a continuing kind of education training class. And this little screenshot was a slide that was trying to educate foster parents on what is not a safety threat during visitation. And a lot of people were really shocked by this. So let me go ahead and share this with you. So for those that are just listening, I'm going to read the two kind of bullet points that are the most concerning. So it says, what are not safety threats for visits? And I have underlined here chronic neglect and lack of sobriety. And especially, I think to your point, Jeanette, when you are talking about these visitations and their rights to visitation and moving to these unsupervised settings so quickly, it's okay if they're high. They're not going to end the visit. Like, it's okay if there's chronic neglect happening and the parent's not changing one diaper for a 5-hour visit. It was really shocking to see that this was education for foster parents.
Yeah, I think that, I think that you can say in some circumstances a lack of sobriety might not be a direct safety threat if it's supervised, if the visit like I did visit supervision. I had parents where I was like, things aren't going so great during a visit, but I was the one who was essentially primarily caring for that child during that visit for the rest of the time, and the parents weren't combative about it. They were still seeing their child. Whatever. It's not great. It's not ideal. I didn't love it. But I was able to like continue with a visit in a safe manner. There's other situations where a parent of a toddler or a baby goes and they use in the bathroom, and it's on their clothes, it's on their person. And, you know, we've had situations where like a parent goes and uses and sticks their hand in their baby's mouth. Like that, like we know fentanyl is so much more deadly.
Right.
And also like using in a bathroom isn't great either. um, so I think that like, yes, you can say that lack of sobriety is not a safety concern, but there is such a continuum of what that means that it can absolutely be a safety concern. And it should be looked at on a case by case basis, not this blanket statement. And I think in regards to chronic neglect, it's just something that 1227 completely dismissed. It's something that, again, like we're looking at development of a child. Neglecting a child is a safety threat. When you are doing it on a consistent basis, when you have resources available to not neglect your child and you do it anyways. The parent who is given food bags and food vouchers and other means of feeding their child, and they still decide to let the food rot because they're using or because of mental health or some other underlying condition, that parent deserves intervention and that child deserves safety.
Right. Yeah, it's especially concerning to me as, a former labor and delivery nurse. just how vulnerable these infants are. And if you're putting them in the hands of somebody who's under the influence, you can absolutely use common sense to expect that that child is at major risk. And when we read the fatality reports, that 0 to 3 is our population of children who are affected the most by this because they're the most vulnerable. You have babies that can't do anything for themselves, that depend solely on a caregiver to fulfill their needs. You've got toddlers that are putting things in their mouth. And so it's just shocking and sickening to know that a parent high during a visit, caring for a very vulnerable child, is not of concern. And they're telling foster parents, just calm down. It's fine. Mom high on fentanyl and she's breastfeeding, which we know fentanyl passes through the breast milk, but it's fine. So yeah, just really crazy. I wanted you to kind of just see that, because I think oftentimes I don't know if social workers really know what they're teaching us foster parents. We don't know what you guys are being trained on, and you guys don't really know what we're being told either. Um, so Travis Couture, the representative from the 35th district, he's been working tirelessly on bills to stop the bleeding in child welfare caused by 1227. Have you had a chance to review his bill for this upcoming session in January?
I did. And I think first, I think Travis Couture has really been amazing at listening to workers, and I really appreciate him for doing the legwork of talking to caregivers, talking to families, talking to caseworkers, like really getting like the perspective of everyone. I think that's really going above and beyond, and something that a lot of our lawmakers haven't done. And it's really disappointing that they haven't done that work. We actually got in touch with Representative Couture because we tweeted at him after 1227 passed. He was elected the next session after that, and we happened to post something about how much we hated this bill, and he commented on it, and we might have been a little snarky in our reply. But instead of being defensive or anything like that, he came to a meeting with social workers, and like that's amazing. And what he got right in that bill with the standard of removal, including that part about imminent physical harm, or I think it's severe,
Serious,
yes,
serious
serious,
harm.
serious harm. It shows the legwork that he's done. It shows the education that he has intentionally sought out, because that hits the nail on the head of what's needed to change.
Do you feel like that would make a huge difference, and that we would be taking a step in the right direction if we could even just get that piece of legislator change to constitute, the serious or imminent physical harm,
Yeah, because
by
it really
adding
takes
the serious in there?
yeah, because it really takes into those chronic neglect situations that we're completely leaving out right now.
Yeah. I also noticed in his bill that that opioids are now going to be considered imminent, serious, or physical harm. And currently, it's not. Currently, substance abuse alone does not constitute imminent physical harm. And so this bill would kind of reconcile that and give the freedom back to social workers and law enforcement to remove children in those situations where there's lethal drugs involved. And we know, just based on what the Ombuds is putting out, that children that are succumbing to this, to overdoses, is 75%. 75% are directly related to substance abuse. And so we are really hoping that Travis can just continue to make headway on this. I know he proposed a similar bill last year and it didn't even make it out of committee, which is incredible, which is really disappointing. And so I know that he does have a few more Democratic legislators kind of on his side, which I am hoping will make a difference this year. Is there any concern you have that about this bill that would give reason for legislators to vote it down? Like any major concerns that stick out to you that you would say, oh, no, no, no?
I think the requirement of keeping cases open is a concern. Um, I think that that's something that can be addressed, because what it says is that you have to have, I think it's 6 months of clean UAs, in order to, start a trial return home. Um, and first of all, like, I don't think that we have the capacity right now as caseworkers to keep cases open longer. That's just the unfortunate reality of, underfunding a system for 2 decades. Um, but also, I think that what we really need to focus on is behavior changes and what those behavior changes look like. Because as a parent, I could get my 2 UAs done early in the month and party. Like, I hate to say it that way, but
Yeah.
party the rest of the month. But I could also be a parent who's in intensive outpatient, who went to inpatient treatment, who has a relapse prevention plan, who's, making all these really big changes. And maybe I did slip up once and have a positive UA during this time period, but I used my plan and I told my worker and I took accountability. That parent who is really actively engaged and like you can see the change and they can talk about the changes that they're making, I'm less concerned about than the parent who's going to their UAs and not really doing anything else.
Right. Right. Yeah, I did. I noticed that too. And just for our listeners, so in Travis's bill, it states that, and you correct me if I don't quite get this right, Jeanette, but parents have to have 6 months of sobriety. And that involves doing, uh, having clean UAs twice a month. And I think what I'm hearing from you, Jeanette, is that that's just not quite enough. That are what would ideally how often would do parents who are in active addiction need to have clean UAs?
So I think it's not really the UAs. I think it's, are you doing treatment? Like, are you actually actively engaging in treatment? So are you going to your individual sessions? Are you going to your group sessions? When you come to visits, are you coming prepared with, food and toys and like other things? Like, are you, staying up to date on your kids' medical? Like, there's a lot of things that when you're in active addiction, like you just don't do. Um,
Right.
and part of our process is not just supposed to be, did you check a box, but it's, did you have real change so that you can be the parent that parents want to be for themselves and for their kids. Um, and I think that like that does take that takes a lot more than just going to UA. So I think it's like it's hard to say, but like we create case plans with parents and those case plans a lot of times include things like attending group, like attending individual, um like you know um in-home parenting supports. That can also happen during visits. And it's that entire team coming together and talking about, have we reduced this safety threat? Have we mitigated the safety threat? And have we reduced the risk? And are we ready to transition into that process? Because I think a lot of times also what we're seeing is that kids are just being returned home without a transition. And that's not really the way things used to be done. And there's a benefit to the kid and to the parents and to the caregivers too, to have an actual transition plan and seeing, is this working? Are there other supports that need to be put in place? So I think it's just making it, and I don't know how you would legislate this, but I think it's like just making it, going back to it being an intentional process of making sure everyone has what they need to stay on a good track.
Right. Yeah, I mean, I'll even say from my experience as a labor and delivery nurse, you definitely saw the difference from moms who came in and gave birth, who, you know, went into their prenatal appointment when they found out they were pregnant and openly had that humility and said, like, I need help. I've been using, I didn't plan on getting pregnant, and I need help. And you can tell there's such a difference between that parent who is focused and is ambitious to to do what's right for her body and her babies. And even when that baby is born, sometimes we still have to withdraw that baby, especially if the mother is on methadone during her pregnancy. And but when she's engaged in treatment and she's committed and she's on a good track, then yes, that's a great scenario of okay, this makes a difference. This with wraparound support systems, this mom has proven that she is committed to getting clean. She's not just talking the talk. Okay, she's walking the walk, right? Doing the hard work that involves getting clean. Um, that is such a different scenario versus what normally happens, which is a mom walks in off the street and just drops a baby in the elevator and there's no prenatal record, and mom is actively using, and there's been no evidence to show that she's going to engage in services. And so before 1227, that was always a slam dunk protective custody case. Immediately, the baby would go into protective custody and services would start for the parent. But we knew that the baby was safe with a foster home, that hopefully wraps their support around this birth family as well. And all of these systems together help build this family back up so they can be one unit together in a safe way. But if you don't have that parent who is ready to engage, it's just like the saying, you can lead a horse to water, but you can't make them drink. And I think that's another, point that's really frustrating with this legislator and hearing people talk about it, is that they're looking at it through rose-colored glasses, and they're not looking at it case by case. They're kind of putting these blanket rules and laws to just cover the whole system, and in return, kids are dying at rates that we have never seen ever in this state. So I definitely wanted just to kind of mention that absolutely I've seen it in the medical field. When parents are engaged, the outcome can be very different. But sadly, that's not the case normally. It's really not.
Yeah, no, it is. And I mean, there's definitely parents who maybe don't engage right away or who weren't engaged during pregnancy. But they do want to go to a PPW. They do want to, get into treatment. And those resources should be available. But we also know that, historically, babies didn't go straight to a PPW with a parent. And they didn't go because their withdrawal happens, because the
They're high
PPW,
risk,
yeah, because the
very high risk.
PPW wants to make sure a parent stays before baby's sent, and that those kids would also have, a plan in place and safety. And I think what we're seeing now is that a lot of cases, they are just closing really quickly. And they're closing really quickly because we we have to be able to prove that there is an imminent risk of physical harm. And when a parent's never parented before, there's no track record of this parent not being able to parent. There's no pattern that we can point to. The baby's been in the hospital, so the hospital has probably been doing most of the care. And the absence of caring for a child under this law isn't an imminent risk of physical harm. We've had cases where, a parent's just visiting for an hour a day at 3:00 in the morning or whatever, because they're using, right? Like, let's be real.
Right.
um, and we are told, well, you can't connect that to a risk of imminent physical harm, because an imminent risk of physical harm, because that parent isn't parenting when they're using, and that's actually a safety factor. That's a protective factor, that they're choosing not to parent when they're using, but they're using all the time. But we can't prove that they're using all the time because we can't even find them except for at 3 o'clock in the morning. And it creates all of these situations that, like, again, the lawmakers just clearly never talk to a caseworker about like what they see on the day to day.
Right. Yeah. In fact, I mean, I even know in my little small community, doctors, pediatricians in the hospital have had to say, no, like, I will not discharge this infant home with these parents. I don't care what CPS says. We are not discharging this infant home. We have way too many concerns. We have, documented them the best we can, and we cannot in good faith send this vulnerable child home with these parents. And sometimes, in some cases, that's kind of been what the investigators need to kind of petition, where they can't, under 1227, they can't articulate, means for putting this child in protective custody right away. But if the pediatrician and the hospital is raising hell and saying, "Well, we're not sending him home. We will keep him in this hospital. We're not doing it." That oftentimes can be used to the advantage of the investigator when she goes to do that petition. I'd like to touch a little bit on services. We kind of talked a little bit about it, but that is also another huge change under this new legislation, is that services are voluntary. And if during the when the case is open, and you chime in too, when the case is open, if parents don't engage in those services after 60 days, then you can't force them. And the case has to close. That open investigation has to close if you can't very articulately explain, the reason to keep it open. Can you talk a little bit about that? Because we've had a lot of social workers kind of reach out with a lot of frustration that there's no accountability. There's no accountability for parents. Here are all these services. It's really up to them whether they want to engage or not. And if they choose not to engage, and DCYF, they can't prove imminent physical harm, then the case is just dropped and the kid is just left in that environment.
Yeah, so what we see a lot is cases where we suspect something's going on, but we can't prove it. And we can't prove that, mental health concerns or substance abuse or lack of medical care is creating a risk of imminent physical harm. So you can have a pattern of parents who aren't taking a child with medically complex needs to doctor's appointments, and an intake will be called in, and they'll take the kid to the doctors, and the doctor will say, well, this kid isn't gonna die or anything like that. There's not going to be serious consequences right now because this medical appointment happened. But they need another appointment in 3 months and 4 months and 6 months to make sure everything's still okay. That time period comes, they don't go to that appointment, another intake gets called in, they take the kid to the appointment, and it's the same pattern over and over and over again, and then eventually it's too late. And that intake didn't get called in quick enough. So that parent didn't follow up. And, at every single point, they're being offered services to make sure that they can keep those medical appointments, but they're not engaging in them. But yet again, it's imminent physical harm. And imminent means like tomorrow, next week. It doesn't mean 2 weeks from now, 3 weeks from now. It's right now. Is something bad going to happen to this kid? And physical is this kid going to bodily be hurt?
Right.
So there's also scenarios where we'll get intakes where there's concerns about, a parent was seen in a car with a child and the parent appeared really under the influence or slumped over or something like that, but we see that parent, the next day or the day after, and they seem okay. Well, do we meet imminent physical harm because of just what was observed? Or, sometimes there's even delays in reporting and they'll say it was 2 weeks ago that this happened. Well, kid's been alive for 2 weeks, so apparently that's not imminent physical harm.
Yeah, it's funny. That exact scenario was actually just on the news. It was somewhere over, in King County, and it was a body cam on an officer, and they responded to a car in a parking lot. Parents were slumped over, passed out on drugs, and there was an infant in the car seat in the back seat. And the officer said, like, we have like CPS just keeps handing this kid back. We keep calling. This is the third time this has happened with this family. We call CPS. They put the kid in foster care, and then they go to the shelter care hearing, and the kid gets handed back. And so, yeah, kind of funny that you mentioned that, because I mean, that's getting, attention by the media as well. And I think that is a frustration that law enforcement has, right? Is like, gosh, I mean, how many times do we have to respond to these environments, right? Where it's like, clearly this is not safe for a child. Clearly this is toxic and lethal. And we're just, you know, I mean, something bad is going to happen eventually, and by the time you can prove imminent physical harm, it's too late a lot of the time. And we're seeing that in the data once again, and it just seems like no matter how many times you say that, legislators aren't hearing you. They're not listening.
Yeah, and we don't track repeat removals. So, one of the data points that the department does track is like repeat dependencies. So, but before you hit that process, there's no tracking of this child has been placed in protective custody 4, 5 times in a year. So what we're not seeing in 1227 is those kids who repeatedly come into care and get returned in a VPA or in protective custody. And we know that every single time a child's removed, that's a trauma. So if you have a child who's been removed 3, 4 times by the police in a year, that's 3, 4 times in addition to whatever caused that child to be placed in protective custody, that child's being traumatized. And again, going back to emotional harm, we don't care about that trauma because that's just
Not in Washington.
that's fine. The kid will be fine.
They're resilient. Like, that's what we hear all the time. And the sad part is that children shouldn't have to be resilient. They're children. That's where adults come in. So
Yeah.
we shouldn't be putting children in those situations where they have to act and function like an adult would, because they're children. Yeah, oh my gosh, I can't even believe it's already been an hour, but we have so much more to unpack. And so I think we're going to have to do like a 2-part series here, but I really wanted to dive into 1227 and how that's impacting our children, especially with the Ombuds data coming out. And so next episode that we have with Jeanette, we're going to dive into how this is affecting social workers, because we talk a lot about how the children in our state are impacted by this. But we want our listeners to know, and I want to know, and I want to learn how this law has also impacted social workers and the workload that is burdening them. And I can tell you, just based on the conversation that I've had kind of off air with Jeanette, that the data is going to shock you with how really we've just left social workers drowning. And the lifeline that we've been sending out has a hole in it. And so it's useless. It's pretty shocking. So I hope everybody tunes into that next episode. And Jeanette, thank you so much for taking the time out of your super busy, crazy schedule to talk to us and just share your heart and the way you are advocating and just kind of being a voice for everybody that you represent. And that's, here at Fostering Change, we are hoping to do that same thing for the community that we represent. And so it was so nice having you on today. I just want to thank you so much. It's really hard to get social workers to kind of go on record with us. So this is a really rare and valuable situation, and we're so appreciative of that. And we will talk to you again soon.
Yeah, thank you so much. And I'm also just going to do a quick shout out to being in a union that lets me actually talk about these things.
Right? I mean, I was a part of a union when I was a nurse, and I wish I had a union rep like you, Jeanette. I absolutely wish I had one like that. So yes, you are incredibly valuable and such an asset to the people that you represent. So thank you so much.
Thank you.
Thank you for listening to Change the Story. If today's episode moved you, please subscribe, leave a comment, and share with friends. The more voices we unite, the stronger our call for change becomes. Until next time, let's stand together, putting our hope in the one who makes all things new, knowing that together we will change the story.